Good morning. Thank you for joining us for this In Conversation. I'm Andrew Guile, I'm a solicitor and a director here at GN Law, and with me is...
I'm Cowles, I'm also a solicitor and I work in the actions against the police department.
Today we're going to look quite briefly at the European Convention on Human Rights and exactly how that works and how that affects the law in our country, and also consider the effects, if any, of Brexit. And I think the place to start is just to explain that it's very easy to get confused between us leaving the European Union and us leaving the European Convention on Human Rights. They're two separate things.
Well, exactly. I think the first thing is certainly, certainly with my conversations with some of my friends, and perhaps certainly when you look at the media, it's difficult to tell the difference, and people assume they're one and the same. So you've got the ECHR, European Convention on Human Rights, and that is distinct and completely separate to the EU, European Union, which of course, following the referendum last year, we're now having this Brexit. Now, in short, us Brexiting, us leaving the EU, does not prevent us being a signatory to the ECHR, and secondary to that, the ECHR, which has its roots from sort of the 50s, came into force in the UK, which we can explore a little bit more via what's called the Human Rights Act. So we've repealed the act that brought us into the EU, but we're not repealing, certainly not yet, the Human Rights Act, and that's very important. But of course, and as we move on in the debate, certainly in the last couple of years, there's been rumblings, especially with the current government, about taking that second step. So first step, fine, Brexit, it is happening, and that's that. But when it comes to this second step about taking it one step further and getting rid of our sort of involvement or the binding nature of the ECHR into sort of domestic law. So yes, I mean, I think not necessarily the best example, but just think of it in footballing language. To some of my friends, I tell them, you've got one club called Manchester City, one club called Manchester United, but they are two different clubs, even though they've got the name Manchester in them. And that's the way to try and think of it in this case.
So, just to hopefully not labouring the point, just to make sure it's perfectly clear to anyone watching, the position is this: we can Brexit in 2 years' time. We are filming this currently in May 2017, so if we Brexit by April, May of 2019, then if nothing else changes, we will still be a signatory to the European Convention on Human Rights. You can still argue your convention rights in courts in this country.
Yes.
Now, until, again, I think it's helpful.
And that Human Rights Act will still be in place because it's a separate
That's
act.
right. So the Human Rights Act 1998 came into force a couple of years later. And what that does is it allows barristers and solicitors in this country to go into courts in this country and actually argue Article 2, Article 3, Article 8 and before our courts. Until the Human Rights Act came in, they couldn't do that. If a UK court made a decision which somebody thought was contrary to the convention, then having failed at all levels in this country, you would then bring a separate case to Europe. And if you won in Europe, if you won in the European Court of Human Rights, then this government or this country would have a duty to rectify or change the laws in this country to be compliant.
Yes.
And so that there was
they
parity between the two laws.
Exactly. So prior to Human Rights Act 1998, the decision as such wasn't binding in the same way, or
no.
Whereas
but
now
now it is. It's what's known as directly applicable. So if you have a European judgment, you can use it in these.
And from the very start, when you first issue a claim, even into a local county court, you can make your European Convention arguments straight away. You don't have to sort of exhaust British courts and then only suddenly bring in convention right arguments when you run off to Strasbourg, which is where the European Court is. And that's one thing that's important. Looking at the next thing, I mean, of course, we won't talk too much about Brexit. It feels a bit of an exhausted debate to some degree, but I think it's about the landscape of where our country's going, and unfortunately, it has divided the nation quite a lot in this regard.
I mean, there's no doubt that certainly part of the groundswell that led up to Brexit was people feeling that there was too much influence from Europe, and it was influence that wasn't the right type of influence, and certainly a move towards more self-governance or less external influence upon how our country operates. And certainly there's the current Conservative government. If we still have a Conservative government in a few weeks' time, obviously there's an election coming up at the time of filming this in May 2017.
And with Labour's manifesto having been leaked only literally a few days ago, and certainly Question Time yesterday obviously explored that quite a bit about some of the differences and practicalities which we can touch on, within the context of that Human Rights Act as well. But yes,
but the Conservative government have certainly issued a paper pre-Brexit, as I read it, setting out quite expressly that their intention, and certainly I assume it will remain their intention if they remain in government next month, to repeal the Human Rights Act, to remove this ability that solicitors and barristers currently have now to directly argue in courts in this country, jurisprudence, what we lawyers call it, or case law that has come before the European Court of Human Rights. So that if the Human Rights Act is repealed and the fresh legislation that the Conservative government want to bring in comes to pass, then this direct applicability of the European Court of Human Rights law will stop. So we will effectively wind back to where we were before. But one thing that this paper makes clear is that in order to change our position and repeal the Human Rights Act and go back to a pre-Human Rights Act position, that will require the approval of the Council of Europe. And this document, again, makes it perfectly clear that if that approval is not forthcoming, then the clear intention, would be to remove ourselves as signatories to the European Convention on Human Rights. It goes on to say that won't be a big problem because the new Bill of Rights and responsibilities that the Conservatives intend to bring in will enshrine and cover all the essential rights that were set out initially back in the convention in 1950.
Well, I think that's certainly what some people say is, if you've got all those rights already enshrined in the ECHR, why withdraw it and then supposedly rewrite the whole thing in its entirety exactly as it is? But of course that's part and parcel of, do we want British courts making our decisions only and little right to go outside of Britain, or having sort of top level European court as the overall matter? And certainly I think the British Bill of Rights is the sort of mooted document. I think that's right, isn't it? And
yeah, I mean, there's a number of points. It's only an 8-page document. I'm sure if you Google it, you'll be able to find it online. It's called "Protecting Human Rights in the UK: The Conservatives' Proposals for Changing Britain's Human Rights Laws." I
mean, certainly, don't get me wrong. My opinion, I'm not going to sit on the fence. I do not want the Human Rights Act repealed. As I'm sure yourself as a human rights
I think it's done a lot of good, and I think my anxiety would be about what would replace it.
Yes, exactly.
And there's no doubt that there's been a number of decisions of the European Court of Human Rights that the Conservative government expressly set out a number of examples in this paper, which they clearly don't agree with. They clearly didn't like at all the European Court of Human Rights getting involved in prisoners and voting and issues along those lines, and a number of other examples. Another one quite a newsworthy example, I suppose, that's given in this paper is of a prisoner who's committed a crime, serving his sentence in this country and then avoiding extradition back to his native country at the end of serving his sentence, because he invoked his Article 8 rights in this country, the right to private and family life, and argued that he should be allowed to stay. And the government clearly want and I think his offence was murder, so it wasn't. It was a very, very
Serious.
serious offence. One of obviously the most serious offence, perhaps, that can be committed outside of terrorism offences. And so, serious offence, very strong desire on the part of the government to send this person home and extradite him at the end of it. He had no right to stay in this country, but he successfully used his Article 8 rights in the courts in this country to remain. And their view is that certainly that sort of opportunity and the end to that case that he was able to achieve, they're quite clear in saying that would not be possible under their new Bill of Rights and responsibilities. So there clearly would be change. They clearly want to rein back upon the extent to which human rights, in their view, has perhaps run riot. But
in short, it's going to be a big blow to human rights in our country, and that where we've got to today, it is a backward step. Certainly, as I look at it, I can't see.
Well, this is, I mean, what you just say there touches upon the issue that I just thought makes no sense in this paper whatsoever, and that it starts by saying, look, the European Convention of Human Rights was set up in 1950. There's been a lot of water under the bridge since then. We've been through the Cold War. We've come out into the 21st century.
And of course, by nature, it coming in 1950 is off the back of
World War
II,
yeah,
which, because prior to that, of course, you've got the UN Declaration of Human Rights, which will still exist and we're still a signatory to. But yes, I mean, it comes out of those sort of horrible events, and you were saying about the Cold War since and it obviously going through some of the history.
But what they were saying was at the start is, look, a lot's changed since 1950, so we need a new human rights law. But then they go on to criticise the European Court of Human Rights of effectively developing and extending the scope of human rights protection offered by the Convention. But logically, the European Court of Human Rights have extended and developed the law
to modernise it.
In order
so it's not 1950 anymore.
Exactly.
Yeah.
So the European Court, I'm sure, would argue and take the view, as certainly I would take the view, that the law has developed to move with the times.
Absolutely.
And so
and they're trying, and human rights
has
to be proactive. Yes, I mean, I agree completely. They've moved with the times in that argument. And so it seems, whilst they're trying to use it as an argument for themselves, it's actually a counter-argument saying, well, self-evidently, when they have been willing to get involved in controversial issues, and they have taken a proactive approach, that is them thinking about the modern landscape, not about how it may have been in the past, but how it should be dealt with. And it is there to try and impose higher standards as time moves on, and that can only be of benefit.
Yeah, I mean, there's no doubt anything that comes in that is new certainly isn't going to extend the rights that have been established in recent years with case law, and the chances are that a number of rights that people do have at the moment and enjoy at the moment will be removed.
Yeah.
It's impossible for me to speculate on what those might be. But there's little doubt that there are plenty of examples of cases which wouldn't have come about had we not been able to use the Human Rights Act.
Well, absolutely. And it also means that when problems have perhaps first appeared in other countries and they've been able to use the ECHR to take it to the European Court in that regard, and a positive decision's been made, it might mean, or it has meant in many situations, we've been able to use that rationale before we've had it as a problem in our country as well. And that in of itself isn't a bad thing, because at the end of the day, problems that can arise in Germany, France, can arise in our country as well. And it shouldn't necessarily be that once they've spotted it, had a decision in the European Court, we need to wait for that problem to happen in our own country and then litigate the exact same thing all over again, rather than being able to sort of borrow or use, within law, of course, the Human Rights Act, but use that positive decision so that we never get to having the problem in the first place. I mean, it benefits from more minds. That's never a bad thing.
But while it's difficult to predict the future with the general move away from European oversight, I would be very surprised if the Human Rights Act is not repealed.
Yes.
Okay, that might be very different if we have a Labour government next month, but if the Conservatives stay in, I would be flabbergasted if we still have the Human Rights Act at the end of their next session.
Yes.
The next 4 or 5 years.
I mean, I think it's fair to say, I think Labour, Liberal Democrats, albeit we don't necessarily get SNP candidates here, but the SNP up in Scotland, Plaid Cymru, they're all parties that want to keep the Human Rights Act, and that's non-exhaustive, Green Party. But so I'm not mentioning all of them, but all of those sort of, I suppose, more liberal parties, if you like, they want to keep the Human Rights Act. They've said as much, and obviously in preparation for this video and just generally, you've got quotes from a lot of senior figures within those parties who did express sort of opinions and reservations about repealing the Human Rights Act. And certainly, within the context of ourselves as lawyers, within police actions as well as other human rights areas, it's fair to say we're all fairly of the same view in regards to it being overall a backward step. But yes, I mean, the Conservatives obviously have that view, and that's, it doesn't appear to have gone away. They're sort of pocketing it for the moment because of Brexit, and I think the Attorney General recently, I think in the last couple of months after the sort of Brexit appeal at the Supreme Court, he's mentioned things like, well, we've got a lot on our plate at the moment, but it's very much not we've changed our mind or we're not intending to do it. It's just simply we can't do everything at once, so let's deal with Brexit.
Yeah.
But once Brexit is over, and perhaps the aftermath is sort of known a bit more, then this plan will get revisited. Especially they're going to have 5 years come, if they win, they're going to have 5 years come June, a new 5 years. Brexit's going to be done in the first 2 to 3 years. That still leaves them a couple of years left in the Parliament to sort of bring it back on the table. So that's, whereas obviously if the election hadn't happened, then 2020 there's a new election, so pretty much you'd have a new election by the time Brexit's finished, and they probably wouldn't have had time to start implementing any changes between now and 2020, bearing in mind it's only 2-3 years away.
So we're certainly in changing times, and the changes might not yet have ended or finished or have shown their face on the horizon. So watch this space. Thank you for watching the video. I hope you found it helpful. There are other In Conversation videos on this site. Feel free to watch some of those. You might find them useful. Otherwise, thank you very much for joining us today.
Thanks.
This video is designed to be a brief introduction to the topic that it covers, and we hope you found it useful. It aims to be informative and to assist people to take the next step in solving the legal problem that they may have. This video does not constitute legal advice and does not seek to solve specific legal issues. If you have a specific legal problem that you need solved, you should take expert legal advice from a solicitor.